Supreme Court was not only critical of the executive, which makes the appointments erratically and illegally, but it also came down heavily on high courts, which grants stay for the asking. Now, what was the type of appointments we were encountering from 1980 onwards? It was not something that suddenly started in 2010 and thereafter. There were cases and cases where, without any advertisement, persons are appointed first on daily wages. Thereafter, they will be put on monthly rated establishment. Then one fine morning, they will regularize their services. The situation became so bad. In one city corporation in Karnataka, out of 4 or 5 chief engineers, except one, rest all were persons who entered services of the corporation as assistant engineers, or what is generally called, irrespective of the designation, graduate engineers, as daily wages, without any advertisement, without any selection process. All that entitled them to join service was that they knew somebody in person, in power. Chief engineer's brother joins as assistant engineer. Then superintendent engineer's son-in-law joins as assistant engineer. It was all a, what I can say, a aggregate of persons who never got selected but were appointed. And at that time, one very important thing happened in Karnataka High Court, because historically, all these regularization cases, landmark cases, if you see, they have all started from state of Mysore, which now the state of Karnataka. I am not telling that in other states there was no irregular or illegal appointments. It would have been there all over the country. But major litigations and the judgments came in this area from appeals arising from the Karnataka High Court. How this UMA Devi case came is a very interesting, it has an interesting background. When some monthly ad hoc engineers or ad hoc employees approached the High Court of Karnataka, one division bench took the view that they are entitled for regularization. Another division bench, which was generally criticized those days as a very harsh bench, it took a view that regularization is impermissible in law, because these are the persons who came without any selection. There was no advertisement. There was no there was no sort of any filtering test or the assessment of these people's eligibility or suitability. And there were certain circulars or government orders issued prohibiting ad hoc appointments. Citing these and many other reasons, the another division bench took the view that regularization of these people is impermissible in law. These two conflicting judgments went before the Supreme Court in UMA Devi's case. And then UMA Devi judgment was delivered. And those were the days when I was frequenting to Delhi. Of course, for the last 7-8 years, I am not going out of Bangalore. At least for professional work. Maybe on a holiday, I may go here and there. That is a different issue. On the day the judgment in UMA Devi was pronounced, I happened to be there in some other case in Supreme Court. The reaction of the advocates was startling. Even those persons who have been in this profession for a good number of years, they had developed a feeling. I would not say that a view, because view is different from feeling. Feeling is something emotional. View is something based on law. The feeling was that Supreme Court has done some great injustice by saying that regularization is not possible at all. That was the extent of degeneration that had set in the matter of public employments. And in my humble view, UMA Devi was long overdue, because we talk of administrative efficiency in government services. How do you measure administrative efficiency? We should not be falling below a certain standard. What is that standard? The standard we compare is neighboring department or similarly situated department in the same state. In the same state, everywhere, if the method of recruitment is same, that is, it is not by selection, but it is by relations, or it is by knowing somebody in the department, then naturally, when you compare with department A's performance with department B, administrative efficiency would not have deteriorated. And there was no standard also, even now. In fact, how this administrative efficiency has become an issue in reservation matters, where what the Supreme Court approved as a measure of administrative efficiency or representative adequacy, those were reversed by subsequently by another three-judge judgment, because this BK Pavitra was rendered in by two judges. Now, coming back to Uma Devi, let me first say one thing. Uma Devi did not tell anything new. It appears to us when we read Uma Devi, or when we speak of Uma Devi, it is something, some landmark judgment. All of us feel that as if a new law has been laid down by Uma Devi. Uma Devi did nothing of that sort. In fact, it only reminded the executive, the bar, and the citizens that, look, this court has told something as early as in the year 1971, that is, to be precise, on 8th December 1971. And over a period of time, all of us appear to have forgotten it. It is time we remind you by a larger bench, that is judgment of 5 judges, that please do not forget what was said by this court in Nanjundappa versus Timmaya. I can speak with some confidence on these characters involved in this particular judgment. In the sense, Timmaya was a very powerful man, because he was principal of a government college when I was a student. He was a very powerful man. What had happened was, he was holding a class 3 post, or what is in some states called as group C post, of assistant geologist. He was appointed as, then he was regularized as Principal School of Mines, which is a class 1 post. Various questions arose before the Supreme Court. First question was whether regularization is a mode of recruitment, because those of us who know service law, at least who are practitioners of service law, we know that generally there are two modes of appointment, two modes of recruitment. It may be it can be direct recruitment, or it can be promotion. Then there is a third method of recruitment also, that is by transfer from an equivalent grade. in a person in some other service or in the under the same government. That is appointment by transfer. First thing the Supreme Court said was that, look, under the cadre and recruitment rules or under the service jurisprudence, there is no fourth method of recruitment. That is, there is no regularization as a method of recruitment. First thing. Second, it was argued whether it was he was already a local candidate. Therefore, he was entitled to be regularized. Supreme Court said there must be a post for you to have appointed anybody even as a local candidate. Because local candidate, in the terminology of UMA DEVI, without going into the textbook definition, I can say that an ad hoc appointee. An ad hoc appointee, he was an ad hoc appointment as a local candidate, but he was not working against any sanctioned post. Therefore, you cannot come up with the plea that he was already a local candidate, therefore we have regularized. That argument is not available to the state. Then it said, what is direct recruitment? How direct recruitment has to be conducted? How persons are to be inducted into service by direct recruitment? Supreme Court laid down three important aspects when it comes to direct recruitment. One is the qualifications stipulated under the rules. If a person possesses, every such person should have an opportunity to compete. Every such person should be able to participate in the recruitment process. Therefore, first requirement of a valid direct recruitment is there must be a notification inviting application, laying down what are the qualifications, what is the method of appraisal or method of selection, then only it becomes. The third thing is that there must be assessment. Without assessment, you cannot appoint anybody. Then the argument was, no, it is neither regularization, those rules may not say anything that regularization as a mode of recruitment. But we have executive power under Article 162 of the Constitution of India. As long as there is no rule, we can regularize by exercising our power under Article 162. Supreme Court said that Article 162 does not confer any such power to regularize. And it said, more so when the initial entry is illegal. Then, though the state did not argue that Timmaya was appointed as Principal School of Mines by promotion, Supreme Court took upon itself to examine whether it could be justified as a promotion. Then the Supreme Court said, look, in a promotion, it can be from one cadre to immediate next higher cadre. Here, you have appointed a person who was in class 3 to a class 1 post. Such a jumping of levels can never be a promotion. Second thing it said, whether it is seniority come merit or merit come seniority, persons will have to be considered in accordance with seniority, of course subject to assessment, and what weight merit should have, that depends upon the actual rule. Therefore it said, when you have appointed a class 3 person to a post of class 1, you cannot even justify it as a promotion. Therefore, Supreme Court clearly said, Article 162 power is not available because it is an illegal appointment. He was appointed against a non-existent post as a local candidate. Second, it said, it was not a case of direct recruitment because there was no process of direct recruitment. Third, it said it is not a promotion because of level jumping and because of not appraising the suitability by any method known to law. All these things have been said by the Supreme Court in two precise paragraphs, paragraph 33 and 34 of R.N. Nanjundappa. Entire UMA Devi can be encapsulated in those two paragraphs of judgment in R.N. Nanjundappa. That is, for those of you who want citation, 1972 1 SCC 409. So Uma Devi is nothing more than Nanjundappa reiterated, interspersed with the saner judgments that had come in the plethora of judgments which were directing regularization. And what are the important things? Because I started my submissions with a statement that it castigated the high courts also. Castigation of high courts is at para 16 of Uma Devi, which those of us who became advocates in 1980s, we would have seen from 1980s beginning up to Uma Devi, we would have seen this almost as a regular happening before every service bench in every high court. A person will come, file a writ petition saying that, sir, I have been working for the last so many years and they are now terminating my services. Even like anticipatory bail, the courts were granting stay orders. They shall not terminate, even where there has been no termination. If there is termination, put him back subject to the outcome of the writ petition. And wheels of justice grind slowly. If he had completed about 8 or 9 years when he entered the court hall, by the time his case is decided, it will be about 15 years he would have spent. All on the basis of the fact that chief engineer was his brother-in-law or father-in-law or some outlaw. Somebody, either by blood or marriage, he is related to somebody in the establishment. And then the court takes a sympathetic view. Tears start jerking. Then say, what is this? He has been working for you for 15 years. You have regular work to be done. If you have not terminated the services of an ad hoc employee for 15 years, it is clear that you have work in your establishment. Why don't you regularize it? Then in a misplaced sympathy, direction is issued to regularize. Whenever a recruitment notification is issued, inviting applications for filling up posts by a regular, lawful recruitment. Those who have been working on ad hoc basis, they all rush to the court with writ petitions seeking regularization. Until the issue is decided, please do not permit regular recruitment to take place. I am sorry to say that even after 18 years of Uma Devi, I still see such interim orders being issued by the high courts. High courts are not at all moved by the observations in Uma Devi at paragraph 16. I don't know whether Uttarakhand High Court is slightly different, but at least some of the high courts I have seen, there is no change at all, because ultimately it is the emotions saying that, look, he has been working. Supreme Court said in Uma Devi, please don't have that such sympathy, because public employment, it can be only in accordance with constitutional scheme of things. What is constitutional scheme of things? Article 16(1), subject, of course, to reservation under Article 16(4), 4A, 4B would not arise at the time of direct recruitment. 16(1) and 16(4). If if there is no vacant post, if a person is not qualified, if a person is appointed without any advertisement, is it not a flagrant violation of Article 16(1)? This stay order employments, Supreme Court castigated as litigious employments. A person getting an employment and continuing by virtue of interim orders, not following any constitutional scheme, not following the recruitment rules, these categories of employment, Supreme Court categorized as litigious employments. In fact, and then it relied on one judgment rendered by Lordship Justice Majumdar in Ashwini Kumar versus State of Bihar. What is the case of Ashwini Kumar versus State of Bihar? Thousands and thousands of appointments were made, far in excess of cadre strength, not following anything known to law. And they had been also confirmed in services. Look at the travesty. There was a time when we used to tell that confirmation is a glorious uncertainty of civil service. That was a statement made a few decades ago. And I have seen cases where regularization takes place just a few days before retirement. Regularization means confirmation. I'm not regularizing, the confirmation. Confirmation takes place just a few days before retirement to enable him get pension. Otherwise, if he is not confirmed, he will have some problem with in the terminal benefits and all that. As against this laid-back attitude in ordering confirmation of people who are lawfully recruited, in Ashwini Kumar's case, all those illegal appointments, they had been given confirmation in service. Then Lordship Justice Majumdar, speaking for the bench, said that when their appointment was void ab initio for not following the constitutional scheme, the question of confirmation of their services would not arise. And if they have been confirmed, it is like decorating a stillborn baby. I have never seen Lordship Justice Majumdar coming out with such harsh language. That was reiterated in UMA DEVI. Then there was another one, Umar Rani case was there, where the Supreme Court three-judge bench had taken a view that regularization cannot be a mode of appointment, and those who come by back door have to go by back door. They should not feel sad. It is easy come, easy go. All these things, Nagarajan values, Nanjundappa values had been reiterated. That was again reiterated by in UMA DEVI. Then it said that whatever judgments are there which run contrary to the present declaration or reiteration of law we are making, they are hereby overruled. But it said certain, it said one aspect at paragraph 53 of the judgment. It reiterated that illegality cannot be regularized. That is a statement made by the Supreme Court in R.N. Nanjundappa's case. It said that if anybody has been appointed on ad hoc basis, if he possesses the qualifications prescribed for the post, and if his appointment or engagement, it would be saner to call such appointments as engagements because they can not be called stricto sensu in law as appointments if such engagement is against a sanctioned vacancy and if such appointee has continued for 10 years in holding that engagement without benefit of interim orders of stay. Because they said very clearly, a litigious appointee has continued eternally. He will not get any benefit by virtue of continuing on the basis of interim orders. These three categories, that is, he must have possessed the qualification on the date of entry, he must have been engaged against a sanctioned post, he must have been in service for 10 years without the aid of any interim order. The governments can regularize such appointments as a one-time measure. Then again, within a few days, Supreme Court itself started deviating from this constitutional norm. One judgment interpreted 10 years as a recurring event. Today somebody is there, irregular appointee, you regularize him if he has completed 10 years. Next year, some other batch completes 10 years, you regularize them. That type of interpretation was also given. Then somebody said, but I think in state of Punjab, some police recruitment, which by UMA Devi standards ought to have gone. Their permanent absorption was approved, or it was held to be, they were entitled to be given the regular appointment. Various deviations are taking place, but fortunately, those of us who believe in equality of opportunity in public employment, we should be happy that there are such distortions post UMA Devi in judicial orders are very greatly reduced. I think a time has now come for another UMA Devi to be rendered by a 7-judge bench, because good things we tend to forget. And over a period of time, the span of memory is getting slowly reduced because we go by expediency and not by any commitment to the constitutional values. Now, I have, while interacting with some of the advocates, they say, sir, Supreme Court has said illegality cannot be regularized, irregularity can be regularized. What is illegality and what is irregularity? We are unable to understand. It is not such a complicated issue. Only thing is, we do not try to read Arananjundappa. In Arananjundappa's case, if you read two paragraphs, para 33 and para 34, no other explanation is required to know what is illegality, what is irregularity. Now, what is illegality? Unless there is a post, there can be no appointment. If a person has been appointed without a post being there, like recently I was reading one aspect, a pre-independence time, there was a Asthan Vidwan, a musician of repute, working in Mysore Maharaja's palace. Then his his son, he got an appointment on completion of his education and he had to go out of Mysore. Then the Sastan Vidwan requested Maharaja that my son is going uh, for employment outside Mysore. Then Maharaja said, I will create a post of assistant director in AIR Mysore station. Because that was under that was owned by the kings. He created a post and he was made assistant director. Then after over a period of time, that post became permanent, all those things that is there. But those could have happened in pre-constitution days and not in the face of Article 16.1. There must be a post. That is number one. Second, there must be an opportunity ought to have been given to everybody who is qualified to participate. Second. Third is, the candidate on the day he entered the engagement or whatever it is, or ad hoc appointment, he must have possessed the qualifications. If these three are not there or any one of them is missing, then it is an illegal appointment. Then what is irregularity? Irregularity means a procedural aspect. If it has been deviated, it is an irregularity which can be regularized. Substantive part of Article 16.1, if it has been violated, it is illegality. A procedural irregularity which does not go to the root of the matter, that is only irregularity. Therefore, the law, which was laid down in Arananjundappa, was again reiterated in UMA DEVI, saying that irregular appointments can be regularized, but illegal appointments cannot be regularized. The very word regularization means there must have been some irregularity. You remove that irregularity or by a process and then you appoint. That's all that the UMA DEVI has said. And I don't think that UMA DEVI has said anything new. And here, normally what happens is, though we do not say anything new, at least we say it differently. Supreme Court did not say anything differently also in UMA DEVI, but it said forcefully and in a manner that would be understood even by the reluctant. That is the greatness of UMA DEVI. It said nothing new. It did not say anything different, but it only said it more forcefully so that everybody concerned. I am saying everybody concerned, that is the executive as also the judiciary, both of them will open their eyes. And it said about the legitimate expectation. What is this legitimate expectation? One of the arguments was that, look, he has been working, there is no livelihood. If he is removed, his livelihood should be protected. Then Supreme Court answer was straight. You cannot pit the right under Article 21 of those ad hoc appointees who knew even on the date of joining that their tenure is not permanent. You cannot say that. You cannot protect the rights of such persons, ignoring the vast mass of citizens who are suffering the deprivation of their right to life under Article 21 because of this backdoor entrance. And about legitimate expectation, though it did not say in so many words, there cannot be any legitimate expectation. That's all they said. But one thing is, for something to be legitimate, it should be lawful. An expectation contrary to law can never be legitimate. Friends, this is the background in which Uma Devi was rendered. This is a reiteration of values. Uma Devi is a reiteration of constitutional values, and we uh, it is necessary because when justice it is necessary to restate. Sometimes we saw about three or four small books being released by, published by Indian Law Institute as a restatement of law. This is one such glorious restatement of law. Thank you, and I see a lot of enthusiasm, and uh, I'm grateful to all of you. Any questions? I will.
Well, sir, well, thank you very much for a magnificent address. It's very enlightening to all of us. If anybody wants to interact with sir, so as I told you, sir, I have three, four questions which has been sent to me prior to this session. If anybody
Yes.
wants to interact, they can unmute their mic and they can directly ask to sir.
Sir, can I
If
have
anybody of
one
you,
question? Sir,
yes,
can I
please
have
go
one
ahead.
question?
Yes, please.
Yes, sir. Is it audible, sir?
Yeah, yeah. I am. Please tell me.
Yeah. Sir, we have seen in Uttarakhand that what state is doing, they are releasing the vacancies which are ad hoc in nature, but they are naming it as a multi-purpose vacancies, although they are doing it in a sanctioned post, but they are keeping it as a named as multi-purpose vacancies. So a person is joining there, but he is having no right, so that he can, maybe he can use it Uma Devi or Chandramohan Negi in the later stages. But the government is barring them the name of those vacancies as a multi-purpose vacancies. So how to counter all those things?
See, against a state atrocity, I would use that word atrocity very carefully and knowingly and without hesitation. Look, contract labor, if you see the evolution of law in our country, contract labor was despised in areas where the work is of a regular and permanent nature. Then if a private employer engages contract labor for work of a perennial nature, courts used to frown and they would say that contract labor is only for some unexpected uh, rush of work, and it cannot be a substitute for regular employment. Constitution has not changed. Same directive principles, same uh, preamble. Then one fine morning I saw government and governmental corporations resorting to contract labor. It has gone to such an extent in higher education institutions. At least that is the position here. I don't know elsewhere. Housekeeping is given to a contractor. Is it not exploitation? Unfortunately, courts are telling that outsourcing is permissible, engaging contract labor is permissible, and when can contract labor move the labor court for regularization? Only where contract is a sham. Therefore, the courts have also started behaving as if there is no law to regulate these atrocities. Because from your question, what I can see is that work of a regular and perennial nature is being got done by employing employees on a ad hoc basis. And what is and they are calling it as multi-purpose vacancies. I don't know what is this multi-purpose vacancy means.
Yes.
Like any work they can assign. For example, if he is a graduate, he can be used as a computer operator. He can be used as first division assistant. He can be used even perhaps to teach primary school students if he has a teacher's training certificate.
And this is how they actually, this is how they advertise this in the newspapers also.
Yes, yes. Those things we will have to challenge. But I doubt very much because in one judgment I saw, I think rendered by Lordship Justice Markandeya Kadju, when a complaint was made about breach of some labor law, he said court's intervention in these matters is it cannot be as it was in the past. What is that past? I cannot understand. In the past also, from 1950, we are having the same constitution. It becomes past as if I am talking of Government of India Act. It is not the same constitution. This exploitation of the lowly paid employees, it can be questioned. And I am not saying that the moment we question, it would be all right. It would be set right. But it is a matter worth trying, because if you have evidence to say that, instead of regular, because UMA Devi clearly says there must be regular recruitment whenever there is a regular vacancy. UMA Devi itself can be utilized to say that this type of ad hocism has to stop. And it is also contrary to what is, though we cannot say stricto sensu bring it under Industrial Disputes Act. It is an unfair labor practice. Any practice by the management to deny the mantle of permanency, like you would have come across, those of you who are practicing either in labor law or service law. Some of the states used to do 89 days, they give an appointment, 90th day, an artificial break, 91st day, again an appointment order.
Same thing has happened also.
This was castigated. And these were termed by the Supreme Court as artificial breaks. Kindly read those judgments of the past. Then you challenge that this itself is something unconstitutional. It militates against all constitutional values. Maybe we get sometime some judge who is socially conscious and to interfere in these type of matters. We want judges who not only read the constitution but breathe the constitution, and constitution should be their way of life. Let us hope that your case goes before one such constitutionalist and we may make some forward movement. It is a very wrong and highly illegal thing they are doing. That has to be corrected.
Thank you so much, sir. It was honor to have you with among us.
Well, sir.
Thank you, sir.
Well, thank you, Mr. Adwal. Sir, there is a question which has been asked prior to this session, which is quite relevant. That one of the young lawyer asked me that that understandability of service was, as sir you said, so sometimes we encountered with by the honorable court with a submission that no employer is a king. So sir, once in a matter I was, since I am a student of law, and I was arguing that employer is a king, but when it comes to the jurisdiction, when it comes to the mandate of Article 12 in Constitution is concerned, so employer can never to said to be a king. Employer can maybe said to have using discretion constitutionally. And sir, as you just said, sir, these submissions are which you have made, sir, Mr. Rajagopal will argue court have to listen. They have to. But sir, if sometimes we make these kind of submissions, it can never got that kind of a weightage. I don't know why, sir. And sir, it was also asked to me by one of my colleagues that UMA Devi is a kind of a confusing law.
There is absolutely nothing confusing in Uma Devi. Uma Devi, you get confused because of the length of the judgment. Therefore, go to a shorter judgment, that is Aran Nanjundappa versus Timaya, which has said all this in a crispier way. After reading Nanjundappa, you read Uma Devi, understanding would be better. Uma Devi had to be a long judgment because so much degeneration has taken place in the matter of employment scenario under the government and governmental sector. They have to tell this is wrong, this is wrong, this is wrong. Because unless we are told what is wrong, we may not appreciate what is right. Whereas Nanjundappa, it came in better times in December 1971. There they could say in a very crisp and short judgment. Uma Devi, the confusion arises because of illegality can never be regularized. And there is a difference between regularization and permanency. Because of these discussions, it became how many paragraphs? I think 58 paragraphs in SCC. I don't know how many paragraphs in EIR. 58 paragraphs. Ultimately, there also, what is relevant is contained in para 16, 31, 43, 53, 54, 55 to 58. About 8 paragraphs or 10 paragraphs if you read. Rest of the things, this judgment is, it doesn't say so, all those things. They start with para Singh versus state of Haryana, all those things are there. 10 or maximum 11 important paragraphs are there. And why we feel that it is difficult to understand is that after speaking all this, tomorrow if an advocate brings to me a case of regularization, as a senior advocate, I cannot run away from that case. Then I will say, naturally, as an advocate appearing in favor of regularization, I may have to argue that Uma Devi did not say what is irregular, what is illegal. Therefore, you can always have the judicial discretion again to try whether it is illegality or irregularity. According to me, this is only irregularity. All those things will be there because that is a professional thing which we do. But to ourselves, we should know what is irregular and what is not irregular, what is illegal. That can be ascertained if we go to some earlier 3 judgments of the year they refer in Uma Devi. That is, one is Aran Nanjundappa they refer. Prior to that, they go back to State of Mysore versus S.V. Narayanappa. These are 2-3 judgments they refer. But I think the essence of Aran Nanjundappa and the essence of Uma Devi are one and the same. And about our getting a hearing, it all depends. See, almost 25 years ago, I think I was arguing a case. At that point of time, almost 30 years ago, even equal opportunities for what is that? Physically uh, huh? Persons with Disability Act 1995 had not come there. I had to argue a case where a person stood first in the written examination, first in the interview, then he is referred for medical examination before issuing order of appointment. In the medical test, all that they write is he is not having one eye, therefore he is not fit for employment. Mind you, it was the post of chief law officer. Then I stood up to open the case. The first reaction from the bench, first question normally asked, what is this matter? Naturally, I answered, a person has been declared medically unfit to be chief law officer only on the ground that he is one-eyed. Immediate response from the bench was, I am sure it was not with any ill intent or seriousness. I have always taken it as to provoke me to argue. Said, yeah, well, what is wrong in that? Bank is entitled to prescribe qualification like we prescribe for daughter-in-law. The girl should have studied this, she should have a particular right and all that. Then immediately I gathered myself, because it was startling. I gathered myself and said, firstly, I am not talking about qualification you prescribe for your daughter-in-law, because that is personal life. I am talking of constitutional values and rejection of a person on this reason. If the medical board had said that, my blindness is of such a nature that I will not be able to discharge this work. That is different. Can you say merely because I am one-eyed, I am not suitable? Then third sentence I said was that, anyhow, I don't know about prescribing a qualification for daughter-in-law because I don't have a son. Then atmosphere lightened, case went on, ultimately I succeeded. Therefore, yes, we face hostile bench. Sometimes court is hostile. And the true test of an advocate is how he meets that hostility. For that, enormous conviction is required and thorough preparation is required. Once you are sure that what you are stating is a fact and what you are propounding is in accordance with law, initial reactions, forget about it. That, because we take wakalat to fight for freedoms guaranteed under Constitution to a citizen. If we don't exercise freedoms guaranteed to us as a citizen even, what is the freedom? First freedom is freedom of speech. If we hesitate to speak when it is our turn to speak, then that would be, I don't say that we are fit to, I would say that we may not be fit to defend somebody else's right when we are ourselves not in a position to exercise our right or hesitant to exercise our right. Yes, that discrimination is there. I have also perceived that if a senior comes the listening will be different, and then if a junior goes, and but most of the, by and large, judges are also changing. They also realize that they also started once they also started as a raw junior. They also know how they grew in the profession. Then they also know that ultimately they have reached a particular destination. Therefore, this initial setbacks, we should take it as challenge and move forward. And about somebody being king, you should tell king is dead and gone. There is nothing called as absolute right.
Yeah. Anybody else want to interact? They can unmute themselves and they can directly ask to sir. Anybody?
Yes, sir, I have a question. Sir, I have a question.
Yes,
Sir,
sir.
my question is Article 311 Clause 1 of Constitution of India, the benefit of this article can be given to contractual employee and temporary employee, or it is just for permanent nature of employee?
The protection under Article 311
Yes,
is
sir.
available even to a temporary employee, but with a rider. Even if you want to terminate a contract employee
Yes,
on
sir.
the ground of misconduct, then Article 311 comes in. But suppose a person is being terminated on the basis of a term in the contract,
Sir.
then Article 311 has nothing to do. What would apply in such a case is pure and simple contractual term. But if we are able to
Sir.
establish that all other contractual employees have been considered, continued, and your client is terminated, his contract is put an end to, for a reason which has something to do with a misconduct, that would be unarguable.
Sir. Sir, it is applicable to the post of APO also. The APO which are appointed by the state for prosecuting criminal cases in a
APP
state.
is also like any other employee of the state. He is an employee of the state.
Sir, could you provide me some judgment in this regard because I have a case?
You have to go to the library and read.
Okay, sir.
Reading,
Okay. I
you are
tried.
reading. You cannot substitute your effort by asking me a question. Make an
Okay.
effort.
No, sir,
Go
I
to,
tried, but
go to CRPC, then go to the judgments.
sir,
CRPC gives an answer. He is an employee of the state.
yes,
And
sir, sir.
in the state, there is nothing called as criminal employee and civil employee. All of us are civil employees. There can be only armed forces employee and civilian employee.
Okay, sir. Okay. Thank you, sir. Thank you.
Thank you. Thank you. Sorry for my harsh reaction.
No,
Sir,
sir. No,
I
no.
thought it is necessary to put you on proper path. Therefore, I had to tell that.
sir, exactly
Okay.
this kind of a question is also asked by one of. So, sir, can we say that that this chapter 14 has an applicability to the government servants because exception has been carved
Yes.
specifically. Sir, can we say so?
It
And
is
sir, as far as this question is concerned, sir, so if APO
And
comes with, sir,
Chapter 14 applies to every state employee,
sir,
but it will not be applicable to employees of public sector. But the principles underlying Chapter 14 will have to be taken as a facet of Article 14 and 16 and imported into employment under instrumentalities of state. It is said that, in fact, in one of the judgments, I think Lordship Justice Chinnapreddy, he said, uh, merely, yes, these people may not be employees serving the state to invoke Article 311, but the principles underlying that cannot be excluded in their application when it comes to public sector employment. I think perhaps it is in UP Warehousing Corporation or something it was said. UP Warehousing Corporation, there it said, where there is no rule, taking disciplinary action is management function, but then it has to be in accordance with natural justice. Then they made this statement also. Vajpayee. Vijay Vajpayee.
Anybody else want to ask any question? Sir, I have many questions. Sir, what we are wishing that today there's a heavy rain and we are also on YouTube live. So sometimes we wish that sometimes sir has some time so that we can have a live session over here. That can be. Sir,
I
there
tell
is
you,
one more.
an
Sir,
advocate remains an advocate as long as questions come to his mind.
sir,
Therefore, people having lots of questions is a good thing. But one advice I would like to reiterate is that when a question arises, your destination should be the library. Whether it is software or hardware or high court library, that depends on your inclination. But question, when it comes to our mind, immediately we should rush to the book. We should rush to the library. Then we find an answer. Maybe we find a better answer than what I give. Yes, in spite of it, sometimes we don't get an answer. That is the beauty of the law that we can always discuss. No problem.
so there's one last question, then we will wrap up. There are a lot of questions. We will carry forward those with our next session because presence of senior like you, sir, will always have something which not only gives a positivity, which because it's always good to react somebody with such an immense experience as you, sir. So there's a question which asked by a junior colleague of mine with regard to Article 309. And sir, we have discussed the preposition. Sir, can we say in the first part of 309 that it says that state an endeavor is given to the state and center to at least make the law in service matters.
Yes.
Sir, can we say? And sir, that is the reason in proviso rule making power is given until the law is made.
Yes.
Sir, some elaboration on this, sir, if.
No, it flows from this constitutional principle that under Article 309, law can be made by the concerned legislature. As long until that law is made, it can be regulated by rule made by the president or the governor, as the case may be. Now, what is this making of the law? Most of the states have now brought the Civil Services Acts, which say that uh, rules can be made by following the particular procedure. Then it is as if it is a delegated legislation which is made by the executive. These days, I don't think that any legislature would make direct law on that. Legislatures would be content by having it done through delegated legislation. Because Civil Services Acts, I am told number of states have enacted Civil Services Act, under which it is a statutory rule is made. No legislature will spend time on making of the rules or the recruitment acts by themselves, except where they feel that a particular uh, scheme is likely to be frowned upon by the courts. They make it by a delegated legislation. When of course, there is a danger earlier once or twice that a similar rule has been struck down and all that. Then the legislatures feel that if we enact it as an act, it will have a greater safety at the hands of the judiciary. I don't think there is a valid presumption, but only in those extreme cases they resort to legislation. Like, for example, when it comes to reservation, they enact in the hope that a legislative act has a greater immunity. Uh, but I don't think, because whether it is a legislative exercise or executive exercise, ultimately, even to test the validity of a legislative exercise, uh, manifest arbitrariness, if it is there. Now, that is one of the tests. Therefore, that difference between legislative exercise and executive exercise vis-a-vis the judicial review is slowly vanishing. As far as employees are concerned, it is equally enforceable, whether it is this or that.
Well, thank you. Anybody else want to? So there's raining, so we are sitting in groups of three, three, four, four in any panel. It's heavily raining over here, sir.
Yeah.
Anybody else want to interact?
Just a final question, sir. Just a final
Yes,
question.
yes, Mr. Latwal.
Sir, 310, the doctrine of pleasure we talked about, is it only applicable for the recruitment and appointment purposes, or is applicable even for the discretionary discretion which the administrative bodies used for making decisions?
All conditions of service are covered by Article 309. Then about the discretion. Discretion, as said in Jaisingari, Article 309 does not say curtail any discretion. For example, promotion is also one of the conditions of service. Naturally, in selecting, you will exercise your discretion or whatever it is. But discretion must be exercised according to known norms, defined norms, and care should be taken to ensure that discretion is not a device to discriminate. Discretion is available even under Article 309. Whatever rule you make, for example, even a recruitment rule we make, ultimately selection has to be done by a body, and person assessing the suitability has some discretion. Then when it comes to promotion, and when we talk of merit, though in that Santaram Sharma's case, Supreme Court said that while employees like all promotions to be made on seniority, it is one of the things that merit may be more appropriate in some cases. We have seen, and you would also have seen as Advocate General of the state, that most of the time the discretion is used to promote what I like than to reward what is really merited. Merit always is a subjective thing. But when you are assessing merit, it should be based on objective norms. That's all the exercise of discretion means. And discretionary things also, it has to be stipulated by a rule made under Article 309. And in case of absence of a rule, 162 executive order.
Sir, if Honorable High Court or suppose Supreme Court is exercising a jurisdiction of 162 and rule is absent, and if a judgment is ruled that regularize that employee, so can that shall I say direction of Honorable Supreme Court comes within the purview of 162? I just
If there is a law, see, the power of the executive is coterminous with power of the legislature. Where there is no legislative enactment, Article 162 can be exercised. But Going back to Nanjundappa, what Nanjundappa said is that Article 162 power is not available to you to regularize an illegality. Because there one of the questions raised was, one of the contentions with the state was that in the absence of rule, we have power under Article 162. Ultimately, what the Supreme Court said is, yes, your power does not extend to regularize an illegality. That is the only thing it was said. If it is illegal, it is illegal.
Yes, sir. Anybody else wants to interact with sir? You can unmute yourself and you can ask a question. Sir, actually the question which Latwalji was asking to you is regarding the whether the doctrine of pleasure 310.
Doctrine of pleasure, if it comes to doctrine of pleasure, read that famous judgment when the where the uh, termination of the tenure of the governors was what is that, Saigal or was Singhal? BP Singhal, if I remember. BP Singhal, the question before the Supreme Court was, uh, governor holds office at the pleasure of the president, because president is the appointing authority. That way, every civil servant holds tenure which is terminable at the pleasure of the uh, governor or president, as the case may be. In fact, some of the dismissal orders issued by the central government, they read, president is pleased to dismiss you from service. But in our law, there is nothing called as absolute pleasure doctrine. Pleasure doctrine is always subject to checks and balances provided by the rules. And where there is no rule, the strongest check and balance is fair play. BP Singhal, I think, BP Singhal versus Union of India. There, the litigation itself had become infructuous, in the sense they would have completed their terms and all that, even nothing, they could not be reinstated. But still, Supreme Court, because important issue of public interest was there, it decided on pleasure tenure. I think BP Singhal is a landmark on the question of pleasure doctrine. And one good thing about our constitution is that what applies to governor would apply to Group D employee also, if pleasure doctrine is invoked. First, for about a week I did not read the judgment when it came. After all, no governor will come to me. Why should I read that governor judgment? Then neither I will become a governor or any governor will come to me. Then one day when I was going through then about pleasure doctrine, all the cases starting from I think that probationer judicial officer, from there it had been discussed. Then I took out and started reading it. And it is every aspect of pleasure doctrine has been discussed. Pleasure doctrine, what happens? Except in the matter, you see, until Sri Lanka Vidyarthi, engagement of government advocate was treated as a pure and simple matter of contract. Like the thought was that government has as much discretion in engaging its law officers as any other private citizen. In Sri Lanka Vidyarthi, it said that it cannot be, but even then, values of Article 14 will have to be followed. Yes, at least that much the court said. I am sure over a period of time, we move towards a case where, to a situation where government cannot arbitrarily hire and fire government law officers. Because it is not a simple case of an ordinary citizen engaging in the services of an advocate. But in fact, in one of the judgments about number of government advocates they appoint, distribution of work, all these things were discussed by Supreme Court. But I don't think that in spite of the judgment, position has changed in any state. I won't use the word in many states. In any state, the situation has remained the same. Whenever there is change of government, en masse change of law officers. Worst thing is whenever there is a change of chief minister, change of law officers, it has become rule of men and not rule of law.
Well, sir, thank you very much. Anybody else want to interact, because we have at least more than 1.5 hours. So if anybody wants to interact with sir, there are then you can directly ask any question regarding this session. Or sir, we wish that there is a lot of question, but we will postpone it to some other session because we are running out of time. Sir, it's highly grateful that sir you are given us time to us. Sir, the video recording has also been done of the session, which will be respectfully sent to you, to your colleagues, sir. Sir, we are highly grateful on behalf of all the junior lawyers at Nainital High Court for sparing us such a great time with us. Sir, highly grateful, sir. Sir, thank you very much for your time.
Thank you.
Thank you very much, sir.
Now,
Thank you.
now
Good
we
luck.
are closing the session.
We'll meet sometime.
Thank you, sir.